Gentlemen, if I could beg your attention, please. My name is Ian Holloway, and it's my good fortune to be the Dean of Law here at the University of Calgary. And if that's my good fortune, it's my real delight to be able to welcome you to the Miller-Thomson panel discussion on legal ethics, specifically talking about after McKercher, that very, very important case. I want today to open the session by expressing my thanks and our thanks, the thanks of all of us in the Calgary law family to the law firm of Miller-Thomson for supporting this. We're blessed in our law school to have happy relations with many law firms, but no relationship is more important to us than our one with Miller-Thomson. They've been with us for a number of years now. Most recently, they were the major sponsor for the International Conference on Legal Ethics, which my colleague Alice Woolley organized 2 summers ago. Just this past Thursday, we were privileged to celebrate the most recent Miller-Thomson scholars in the law school, and today we're here to celebrate them further through their very generous sponsorship of this panel discussion on legal ethics. And I want to introduce my friend, Kent Anderson, a senior partner at Miller-Thomson. Kent is known to most of you who've been at the bar in Calgary for a number of years. Kent is formerly the managing partner of the Calgary office of Miller-Thomson, and it is he who I had the good fortune to work with when we began to set up this current relationship. Kent is in a way a type of lawyer that we don't see often anymore, and that he actually is a barrister and solicitor. Kent represents a number of clients in the energy, more specifically oil and gas sector, but he also is not a stranger to the courthouse. So colleagues, friends, I'm wondering if you could join me in welcoming and expressing our thanks to Kent and his partners for allowing us to be here today. So.
Well, thank you very much, Ian, and thank you to all of you for coming out today. As Ian mentioned, it has been our privilege and our pleasure to enjoy a strong relationship with the U of C Law School, and Ian in particular, since he arrived, I can't remember how many few years ago, but not too many. And it was a great opportunity for us to make a commitment to the university, and in particular to sponsoring a number of the legal ethics initiatives, including this one today. Ian mentioned the kickoff event was, from all reports, I think a highly successful International Legal Ethics Conference that was held in Banff in July of last year. And there were people there from all around the world, academics, jurists, practitioners, and it was really a pleasure for us to be part of that. And it was a testament to Alice's strong organizational skills that it was as successful as it was. Our commitment also included supporting the Miller-Thomson Prize in Legal Ethics, which is awarded annually to 2 top students in ethical lawyering, which is a course taught, I think, by Alice at the law school. And then we have this speaker series that we are supporting as well. And we made the decision to support it, and are so pleased to do so because, frankly, I personally and my partners and colleagues believe passionately in the importance of maintaining the highest professional standards and the highest ethical standards for our profession. We believe in ensuring that the public receives the fair and ethical representation that they're entitled to expect from us. And we just think these kinds of initiatives and these kinds of conversations can only help to support that outcome. Now, today's discussion, I think, is going to likely focus on conflicts of interest, given the reference to McKercher, and that, of course, is a vexing challenge that faces all of us in the public practice, particularly those of us with some of the larger national and even international firms. We've certainly got a well-informed and esteemed panel here today, and I'm looking forward very much to the discussion. I just grabbed one little clip out of the McKercher decision that perhaps gives a bit of a segue into what we're going to hear today. And the court was referencing the Martin decision and had this to say: a fair conflicts rule must strike an appropriate balance between conflicting values. On the one hand stands the high repute of the legal profession and the administration of justice. On the other hand stand the values of allowing the client's choice of counsel and permitting reasonable mobility in the legal profession. The realities of large law firms and litigants who pick and choose between them must be factored into the balance. As was the case in the English common law, the court declined to endorse broad rules that are not context sensitive. And that's probably kind of where we are, as near as I can tell. Context is everything. So with that, I'd like to introduce our panel, who's going to share their thoughts and insights with us today. Brent Cotter, professor at the College of Law, University of Saskatchewan. Brent is a former dean at the University of Saskatchewan. He obtained his Bachelor of Commerce degree with honors in 1971 and Bachelor's of Law in 1977 from Dalhousie. From 1992 to 97, Brent served as Deputy Minister of Justice and Deputy Attorney General for the province of Saskatchewan. And in 1997, he was appointed Deputy Minister of Intergovernmental and Aboriginal Affairs, as well as Provincial Secretary. He's a current member of the Law Society of Saskatchewan and the Nova Scotia Barristers Society. And in 2008, Brent was selected as recipient of the CBA Saskatchewan Award for Distinguished Service. So, Brent, welcome. Look forward to your comments today. Malcolm Mercer comes from the McCarthy Tetrault Toronto office. Malcolm is a partner in the McCarthy's litigation group with 30 years in practice. He currently acts as general counsel to McCarthy's and is the former co-leader of its national litigation practice. And he maintains a civil litigation practice with an emphasis on corporate and commercial matters and professional negligence. He's also a bencher of the Law Society of Upper Canada, chair of the Ethics Professional Regulation Committee, and co-chair of the ABS Working Group. And he's chair of the Ethics and Professional Responsibility Committee of the Canadian Bar Association, and also a member of the CBA Task Force on Conflicts. And if I noticed right, you were also counsel on the McKercher case, Malcolm? Probably have some insight from that. Steve Raby is a senior partner at Norton Rose Fulbright in Calgary, or as those of us been around for a while, the old McLeod-Dixon firm. Steve practices in commercial real estate law and maintains a dynamic commercial real estate practice. He's got extensive experience in all aspects of real estate transactions and everything related to it. He was president of the Law Society in 2013 and is currently an Alberta Council member to the Federation of Law Societies. So it'll be interesting to have a solicitor's perspective. Steve, thank you and welcome. And lastly, Alice Woolley, who organized things here again today, I'm sure. She's a professor at the Faculty of Law here at our University of Calgary. Prior to joining the faculty in 2004, Alice practiced law in Calgary, worked in the areas of utility regulation and civil litigation, and her academic specialty is in legal ethics and professional regulation, and she has a particular interest in the intersection between professional regulation, moral philosophy, and moral psychology, which sounds intriguing and fascinating to me, Alice. I know you didn't come here to listen to me, so I'm going to sit down now and turn things over to Brent, who is going to lead the discussion.
Now we're going to try and make this work. There's a PowerPoint presentation that we'll go through, but I don't know how to get rid of this screen even. Malcolm's not only gifted litigation counsel and leader in ethics, but obviously as well advanced with respect to technology. Thank you. Before I begin, I should just offer this one disclaimer. As you've heard, I'm a professor at the University of Saskatchewan College of Law, and I'm a former bencher of the Law Society of Saskatchewan. Thank you, Malcolm. But I just wanted to say that anything I say today is not necessarily the opinion of the College of Law or of the university where I work, nor is it necessarily the opinion or view of the Law Society of Saskatchewan, and nor are they necessarily my own opinions. Okay, perfect. Thank you. I have slightly more time than the others because I think it's fair to say Alice gave me the license to describe to you the facts and circumstances and shape of the McKercher decision as part of my remarks as the kind of lead-off commentator. The title of my remarks is borrowed from a paper that Richard Devlin and I have written for the Canadian Bar Review entitled 3 Strikes and You're Out, or Maybe Not. The reason for the title is this. In McKercher, most of the way through, and certainly ultimately in the Supreme Court of Canada, the McKercher firm was found to have violated its obligation to avoid conflicts of interest vis-a-vis its client, CN. Secondly, it violated its duty of candor to the client. And thirdly, its duty of commitment to the client. Those were the 3 strikes to which the title refers. But as you may know, at least at the Supreme Court level, the court, in a unanimous judgment written by the Chief Justice, sent it back to the trial court judge to determine whether the McKercher firm should be disqualified, hence the reference to, or maybe not. My remarks are going to follow along these lines, a little bit of the context and a very brief overview of the jurisprudence to which Kent referred. Secondly, the McKercher decision, the facts, issues, and decisions. What we have described, trying to keep with the baseball metaphor, home runs by the court, 2 or 3 what we have called drop balls, and then some what we've called new signals and new signs coming out of the judgment. So let me just dive right in. So the first then is what I've called the context, the conflicts trilogy. Martin and Gray, a case decided in the early 1990s by the Supreme Court, a case out of Winnipeg, in which a lawyer representing a client in an estate litigation, firm dissolved, she joined another firm. That firm happened to represent the client on the other side of the litigation. She was not involved in the litigation, but a disqualification motion was brought against that firm that she joined. And ultimately that disqualification motion was successful and the firm was disqualified. Largely on the basis, and you've heard of the framework from Martin and Gray, or the McDonald estate case as it's sometimes called, that the information that she had was at least created at least a perception of the possibility that that information would be transferred to lawyers who are involved on the other side of the litigation. And the risk to impropriety and compromise to the integrity of the administration of justice was seen by the Supreme Court to be too high to allow the firm to continue unless institutional frameworks were put in place that could protect those kinds of situations. And as you will know, in all of the provinces, institutional mechanisms, so-called Chinese walls, cones of silence, and the like, were instituted as rules in law societies to make that possible. Subsequently, about 10 years later in 2002, a case was decided by the Supreme Court called the Queen and Neil, and in large measure, the issues that have flowed into McKercher revolve around the decision in the Queen and Neil. The facts of that case were simply that a lawyer egregiously took advantage of both information he obtained in confidence from one client and then some other strategic information that he learned and used them against that client's interests in what mostly you would be inclined to call a shameless fashion. And when the client found out about it, it was a criminal matter. Mr. Neal, the client, found out that he'd been stabbed in the back by his lawyer. He tried to have his convictions for fraud set aside. He was unsuccessful. He made an application all the way to the Supreme Court to have them set aside for essentially an abusive process generated by his lawyer's behavior. The court did not grant that, but established a framework in a judgment written by Mr. Justice Binney, to which I think a number of us may refer. And in that judgment, Binney tried to write a framework for the circumstances where a lawyer or law firm is representing two clients at the same time, so-called current clients in the nature of conflicts of interest. This is the rule, the bright line rule that Justice Binney established. I'll just read it. We'll come back to it, I think, once more. The bright line is provided by the general rule that a lawyer, meaning law firm, may not represent one client whose interests are directly adverse to the immediate interests of another current client, even if the two mandates are unrelated. That's the bright line rule, unless both clients consent after being fully informed, and a subsidiary requirement that the lawyer reasonably believes that he or she is able to represent each client without adversely affecting the other. The first part of the rule, I think, presented an enormous challenge for lawyers and law firms and has been the subject of controversy ever since. There is a third case in the trilogy known as Strother. Strother is a case from British Columbia. Interestingly enough, and I don't know whether there's some meaning in this, each of these four big conflicts cases come from Western Canada, one from each province. In Ontario, they never have these kind of problems. Malcolm will no doubt, I wanted to get that out before he said it. In any event, the case in Strother was a case in which a tax lawyer, Strother, with Davis and Company, was providing high-level tax advice to a company involved in the film financing business and the tax deductions, super tax deductions that flowed from that. That business was wound down as a result of the so-called loophole of tax deductions being closed. The firm and Mr. Strother continued to represent the client, Monarch Entertainment, who were the film financing company. But he and a laid-off employee came up with an idea that there might still be an opportunity, there might still be part of the tax loophole open. They made an application to the Canadian tax people, and they were successful, and all through that time, Strother, I would say, quite carefully avoided telling Monarch of the opportunity as their business was being wound down to nothing. They felt that he'd breached his fiduciary obligation by failing to disclose that information, and proceeded with litigation that went all the way to the Supreme Court. One of the complicating features of Strother was that in this new venture that Strother sought the favorable tax ruling for, he and the other fellow, suitably named Dark, planned to go into business together, and that was what happened when they got a successful ruling, and Mr. Strother and Mr. Dark made a lot of money in the 2.5 years before the loophole was closed. Mr. Strother was ultimately found by a close call, a 5-4 decision in the Supreme Court of Canada, to have violated his fiduciary obligation. And essentially the court recognized and continued with the bright line rule, although it began to place some frameworks around it, to which I will refer, and I expect now Malcolm and Alice will as well. So that's the kind of setting that existed when the McKercher case came along, and in some ways an ideal opportunity for lawyers and for the Supreme Court to address, potentially reconsider the richness and high standard established by the bright line rule. This is the kind of sense of what I'll say about McKercher. And let me just describe to you the circumstances of McKercher if you're not particularly familiar with them. In 2008, the McKercher law firm commenced a class action on behalf of a farmer, Wallace. The case is actually Wallace versus CN, against CN and others, alleging that they had systematically overcharged grain farmers with respect to grain transportation charges over the period of the previous 25 years. The claim was for $1.75 billion. And there were a series of allegations of, I would call it, reprehensible behavior on the part of CN. At the time, the McKercher firm was representing CN on 4 unrelated matters. It had been one of CN's lawyers in Saskatchewan, and in the previous 5 years had billed CN $70,000, about a third of the amount of money that CN had paid to law firms in Saskatchewan over that period of time. At the commencement of the action, that is McKercher beginning proceedings against CN on behalf of Mr. Wallace, McKercher was representing CN on a real estate transaction, which it sought to continue on, but CN refused. A litigation matter with respect to which, just prior to the commencement of the suing on behalf of Wallace, McKercher notified CN that it was withdrawing as counsel. You can see a dimension of lack of commitment. I think that's an example of what showed up in the Supreme Court. Thirdly, the McKercher firm was representing CN on a receivership matter, which shortly after it started on behalf of Wallace, McKercher withdrew. And fourthly, two of the lawyers with McKercher held powers of attorney on behalf of CN in Saskatchewan, which they terminated shortly after the litigation began. CN wasn't particularly happy to be sued by its own lawyers and brought an application to have the McKercher firm disqualified from representing Wallace. CN generally did not consent to having law firms act against its interests, but had not shared this policy with McKercher. None of the matters that I've mentioned, those four other matters, were related in any way to the Wallace litigation. McKercher had gained information about CN's approach to litigation, its business practices, and its risk perspective and tolerance, an issue that shows up as to whether this is confidential information or not. But the law firm was not privy to any specific confidential information related to this litigation. At trial, the court focused on these main points. At the trial level, the trial court judge, Chief Justice Popescu, found that that information I've just described did constitute confidential information in the possession of the McKercher law firm. That view was rejected by the Court of Appeal and ultimately by the Supreme Court. So this is a case where confidential information is not at play according to the findings of the most senior courts. Each level of court, I think it's fair to say, recognized that the law firm failed in its duties of candor and commitment. At the Court of Appeal level, that's quite clear, but the court said that those kinds of failures on part of counsel are not appropriately addressable by disqualification, but by sanctions that a law society might impose. The big issue, I think, for us is the view that got taken by the courts as to whether or not there was a conflict of interest and whether the bright line rule or some other approach governed these circumstances. And in that respect, the trial court and the Court of Appeal preferred a more moderated interpretation of the bright line rule that has been advanced since the mid-2000s decade by the Canadian Bar Association, a test that revolved not so much around the literal application of the bright line rule, but on the application of whether there was a substantial risk that a client's interests were put at stake. And in those respects, the Saskatchewan Court of Appeal, in a unanimous judgment, found that those risks were not put at stake in these circumstances. As well, particularly in the Court of Appeal, and to some extent in a slightly different way addressed by the Supreme Court, there's consideration given to whether CN constituted this narrow class of clients who are described in the Neal judgment as professional litigants. That is, that they essentially are they have wide-ranging activities, often generating litigation, and with respect to unrelated matters, they give a form of implied consent to being sued by their own law firms, provided the matters are unrelated and there are no confidentiality concerns. And in the lower courts, with respect to professional litigants, CN was found to be such a professional litigant quite clearly by the Saskatchewan Court of Appeal, and as a consequence, the interpretation leads to an understanding that CN had given its implied consent to McKercher to be able to bring the Wallace action against it. As well, the court says in those kinds of circumstances, that implied consent cannot be withdrawn by the client once the proceedings begin. In other words, it was acceptable at the Court of Appeal level for the law firm to begin these proceedings against it. And as a result, the remedy was no disqualification, but perhaps McKercher open to being sanctioned by the Law Society of Saskatchewan if a complaint was made against them. I think that kind of lays the terrain for moving now into the decision by the Supreme Court of Canada. CN, unhappy, appealed to the Supreme Court and was granted leave, and both the Canadian Bar Association, who Malcolm represented, and the Federation of Law Societies, was represented by John Hunter from Vancouver, obtained intervenor status and engaged in a lively presentation of the case, I think. I went and watched, and it was, I think the language for you litigation lawyers is it was a hot court, and it If you've ever had a chance to watch a webcast of it, or would like to, you'd find it highly engaging. Outstanding counsel all around. So observations about the decision in the Supreme Court of Canada. The approach, I think, produces a richer and more precise analytical framework and a relatively short judgment, a unanimous judgment written by the Chief Justice McLaughlin. It, I think, clarifies the law around these questions. I don't think it's, I think we will examine questions at the edges of the decision, and some of that discussion might take place here. But the law is, I think, now more precisely articulated with respect to current client conflicts of interest than has been the case in the past. With respect to the bright line and the bright line rule, I think it's fair to say that the bright line has been confirmed by the Supreme Court of Canada, and I'll show you a passage from the Chief Justice, I think, that makes that fairly clear. What the court did do in language of scope is identify the reach of the bright line rule and its limitations, and identifies 4 constraints on the application of the bright line rule, and I'll mention them for a moment, and offers some helpful views on the lawyer's duty of commitment and candor, each of which the McKercher firm was found to have failed to live up to their obligations. So I'm mainly going to speak about the 3rd, 4th, and 5th here, bright line rule. This is what Chief Justice McLaughlin said. Where applicable, the bright line rule prohibits representation. It does not invite further considerations. It's the product of balancing of interests and not a gateway to further balancing. And to turn the rule into a rebuttable presumption or some balancing exercise would be tantamount to overruling Neal and Strother, which the court was not prepared to do. In other language in the court, it is clear that in the circumscribed way that the court proceeds, the bright line rule is the governing rule. And if you are in violation of the bright line rule, you are almost sure to be disqualified, subject to some other factors being brought into play. So that's the rule about current clients, unrelated matters, directly adverse. You can't proceed unless the clients consent. And even if you are able to avoid the bright line rule, the court says the next test is whether or not, in your judgment, even so, the client might face a substantial risk of a qualifying and limiting interest that you as the lawyer might have, or some partners in your firm or the like. The scope of the bright line rule, that is the framework for it and the limitations of it, are captured, I think, in these 4 points. Firstly, the interests at stake of the 2 clients have to be immediate and they have to be directly adverse. Secondly, those interests in terms of adversity have to be legally adverse. The court acknowledges and endorses what you might think of as business interests being in conflict, 2 clients bidding for the same prize. And Strother is a good example of that. If you think about Strother, Mr. Strother and his company were going after investors for these film financing deals. So was the Monarch Company, and it was an example of 2 competitors for the same prize. That's a legitimate representation. It's not a legal conflict. Thirdly, using disqualification for tactical purposes is an abuse of the administration of justice and won't be countenanced. And lastly, on this question of professional litigants and them giving implied consent for their law firms to sue them on unrelated matters, the court substituted for that test a different test, and that is whether in the circumstances it would be unreasonable for a client to withhold consent to be sued by its own lawyers in an unrelated matter. I think a test that will have to be worked out, but it's, I think, a more satisfactory one than the test that was in place around professional litigants. On candor and commitment, the Chief Justice made a series of observations about this dilemma. You're representing Wallace, and Wallace wants to sue CN. Let's say in other circumstances you can. One of the challenges is to provide full disclosure to the existing client, CN, in order to honor your duty of commitment and candor to them, which often then requires Mr. Wallace to agree to tell things about the case that would normally be thought of as confidential information. And the way in which the Chief Justice resolved this kind of dilemma is to say, the lawyer's duty of candor must be reconciled with the duty of confidentiality toward the new client. In order to provide full disclosure, the lawyer must first obtain consent of the new client to disclose the existence, nature, and scope of the new retainer. If that new client, Mr. Wallace, would have refused to do that, the lawyer can't fulfill the duty of candor to the existing client, CN, and can't take the new file. So that there's a requirement that the new client has to put a little bit of water in his confidentiality wine in order for the litigation to proceed. This is all assuming that the other problems are able to be resolved around the bright line rule and substantial risk. Drop balls. This is a point that Richard Devlin is fond of. He thinks that the language should have been about a rule and exceptions as opposed to the scope of the bright line. I don't fully understand the point, but we wrote the article together, and that's a paragraph or two that he put in. Don't tell him that, Mel. The court conceived of its role as a limited role of working through and managing the administration of justice, and not, as we say in the article, having to decide between the two arguments of two petulant children, in this case the CBA and the Federation of Law Societies. This is what Chief Justice McLaughlin said. Sort of the debate has been transported between essentially the CBA and the Federation into proceedings before us, and each of these interveners asked the court to endorse their approach. And the court said that's not our job. We don't deal with petulant children here, except maybe in family law. And I think our argument is that this was too dismissive of the perspectives of the CBA and the Federation, which were legitimate, carefully thought out positions in contradistinction with one another. In my view, the court did make the choice and chose the view of one of the petulant children over the other, and that was the Federation's view. And remedy, let me just go back and say this. As I mentioned, the Supreme Court fashioned this framework, but decided not to pull the trigger, basically, which I think certainly would have lent you to see McKercher disqualified. I have some observations about firm strategies, and I think it requires more precision regarding retainers and termination of client representation to avoid too many current client conflicts. There's a model of advanced consents from clients that can be developed. It's fraught with some challenges. Then thirdly, the potential for law firms to establish what are called ethical infrastructures. And then this is a series of possible amendments to the Code of Professional Conduct and the Model Code in particular that would incorporate some of the provisions of the McKercher decision. And I'm going to stop there. I think that kind of covers the terrain, and I'll now get out of the way.
So from my perspective, there are a whole bunch of different ways that you can come at McKercher which are interesting. It's interesting as a matter of fiduciary law and of the administration of justice. It's interesting as a matter of the role of the courts as opposed to the role of the law societies. But Brent and I did a presentation by webinar back, I guess it was in January, for the CBA. And we did polling through the course of the webinar, and it was clear to me that nobody understands any of this. That as a result of the polling, we almost never got more than 55% in agreement on any fact scenario being a conflict or not a conflict. One of my heroic moments was when I was the only one out of 150 people to have a particular view, and I thought I knew something about it. And maybe I do, maybe I don't. So what I want to do is focus in this presentation, and Alice is nervously wondering whether or not I'm going to be too long, on trying to draw some practical, simple lessons from McKercher. And my theme is it's not just about the bright line rule. In fact, I'm increasingly of the view the bright line rule is less important than we think it is. Not that it's irrelevant, but rather that it misses a number of points. So you've heard about Neil, and what I want to emphasize is that Neil gives us the 4 C's. This is in the nature of a mnemonic. Remember 4 C's. Confidentiality, avoiding conflicting interests, the duty of commitment, and the duty of candor. People argue theoretically whether or not the duty of confidentiality fits in this list as a fiduciary obligation, but it doesn't matter. There are 4 C's. So coming to McKercher, let's talk about one of the 4 C's at the outset. The Chief Justice says that the duty of commitment, and you'll remember that the McKercher firm fired their client. In fact, they fired them without telling them they were litigating with them. She said the duty of commitment prevents the lawyer from undermining the lawyer-client relationship. That's a fairly deep thought. It's not just about firing clients, it's doing things that undermine the relationship. One of my sadnesses about arguing the CBA position over the years is something that I think we did well was focus on the importance of the relationship between lawyer and client and how it can be a fiduciary breach to impair that relationship, not in a rules-oriented way, but in a principles-oriented way. So I like this phrase, and I think it's quite important, and I think we lawyers can start to look at codes of conduct like tax statutes, and we shouldn't. What we should do is understand the primacy of the relationship. What the Chief Justice then said was that you can't summarily and unexpectedly drop a client simply to clear conflicts. I worry about her language there because it suggests that as long as you don't do it summarily and they expect it, it's okay. I don't think that's true. The Law Society Code of Conduct says that you can't withdraw without good cause and on reasonable notice. I think that's a far better statement of the proposition. And just so we're clear, getting a better retainer is not good cause. As the Chief Justice said in another passage, which I think is easily supportable, McKercher was bound to complete those retainers unless the client discharged it or acted in a way that gave McKercher cause to terminate the retainers. So the first lesson, above all else, or at the top of it anyway, is you don't get to fire your clients in your self-interest. And McKercher was inevitably going to lose this case because they did. The second is the duty of candor. And Justice Binney said in the Neal case that you can't keep your client in the dark about matters you know to be relevant to the retainer. The Chief Justice made it clear that just because the lawyer thinks there wasn't a conflict, just because the lawyer thinks the bright line rule is not engaged or the substantial risk principle is not engaged, doesn't end the inquiry. The client is entitled to have a different view. You can't be secret about your choices because the client legitimately may have a different view. And secondly, the client's entitled to fire you. And just because you think there isn't a client doesn't mean that the client doesn't get to say, I don't give a damn if there's a conflict or not, you are fired. And so the duty of candor quite clearly requires that the client be told of everything that might be relevant to the client about the retainer. But I want to highlight something else, and that is that the duty of candor, and it can be misunderstood if you just read the McKercher case literally, is not just about the retainer, but is also about the case or the matter itself. Lawyers have an obligation to disclose all that they know that is relevant to the representation of the client, not just whether the lawyer should be representing the client, but the substance as well. And I've given you two appellate cases, one from Ontario, referring to a BC case, and also a recent Saskatchewan Court of Appeal case. The Law Society Code says that the lawyer must advise the client of all information known that may affect the interests of the client in the matter. That's a perfectly good, clear statement. I think it's a little bit overbroad if we think about it because it doesn't contemplate, for example, confidentiality orders in confidential information cases, but as a general principle, it's right. The problem with lawyers who have duties of candor and duties of confidentiality is they can get in the way of each other. We have this wonderful obligation to keep secrets perfectly and disclose things perfectly, and that gets complicated. And what the Chief Justice made clear in McKercher is that when those two collide, just because, well, let me quote from the House of Lords in Hilton and Barker Booth, which I've always enjoyed, just because you got a problem doesn't mean you got an excuse. They didn't say it exactly that way, but that's effectively what they said. Just because you have two duties that conflict doesn't mean that you get to ignore one of them. So in the context of a new retainer, what the Chief Justice said for McKercher is just because your client won't let you disclose the new retainer doesn't mean that you get to take it on without disclosing it to your existing client. The answer is where those two duties collide, you don't get to take on the new retainer. You've got to observe them both. That may be unfortunate for the lawyer, but both have to be honored. So what I've wanted to do up to now is simply highlight that confidentiality matters, candor matters, and commitment matters. And if you don't think about anything else from McKercher, but you think clearly about those three things, there'll be a great benefit from thinking about the case. I want to deal with the last C, which is why McKercher is more famous. And the first is the duty to avoid, or the way into it is the duty to avoid conflicting interests. And what I've given you here is from Neal, Struther, Sharburn, Son-Intellects, McKercher, and Golumbos. Let there be no doubt what a conflicting interest is. The Supreme Court of Canada, in those 6 cases in the last decade, has made it clear that a conflict is that which gives rise to a substantial risk that the fiduciary's performance of their fiduciary duties will be impaired. And for lawyers, that's about client representation. We're not talking about the certainty of impairment. We're not talking about the probability of impairment. We're talking about the real risk of impairment. What I think is interesting about the bright line rule is what the Chief Justice says in paragraph 38 of McKercher. Having set out again the substantial risk principle, she then says there is only a deemed conflict of interest if the bright line rule applies. And so Brent and I do think about McKercher in a number of ways differently. One of the things that, to my way of thinking, is important is to recognize that the bright line rule is trying to find out if there's a substantial risk, a true conflict. It's a deeming of a conflict because it's a pretty good rule for finding it, and it should simplify your thinking. But the point that I want to make is that true conflicts are what this is really about. It's about interests, personal interests, self-interests, or duties to another that risk impairment of your duty of representation of your client. I believe we've got confused about that simple proposition. And when we had the webinar, I think it's because people have started to work through their way through the complicated former client, current client, rules of conduct thoughts. And I think we can't think anymore about what really matters. Now, let's look at the bright line rule. I've given you the statement from the Chief Justice, which talks about the various limitations on the scope. It's up there. Brent's already taken you through it. I want to highlight some parts of it and ignore some parts of it. First of all, the concept of immediate interests of clients directly adverse. What the court makes clear, I think, is that the bright line rule is not about the interests of the client in the two retainers or the clients in the two retainers bumping up against each other. In Neal, those were strategic interests. In Struther, those were commercial interests. What the Chief Justice says, I think, is that we're really talking about legal, direct legal rights and obligations between the two clients inter se, as opposed to their interests more broadly. And what she also says is that these legal interests have to be directly adverse, not indirectly adverse. And what I think she's really saying is that unless the counterparty in litigation or in a transaction is the current client, the bright line rule doesn't get to be examined. And what I reinforce, or doesn't get to apply, what I reinforce, though, is you've always got to go back to the substantial risk principle. Just because you've reasoned your way through the bright line rule isn't the end of the examination, and probably, I think, is not terribly important. I'm skipping over the tactical abuses point because the court made it pretty clear in its elaboration of that their test for a tactical abuse is so tight that in the real world we'll never observe one. It's the unicorn of conflicts law. It theoretically exists, but it's practically unimportant, or theoretically may exist. What does matter, and I think why Brent is sort of right and sort of wrong, he says that the court clearly accepted the bright line rule, and they clearly did. What they then did is, by way of a scope limitation, is brought all of the issues which the CBA argued should be considered as to presumptive rules into this statement. The bright line rule does not apply in circumstances where it's unreasonable for a client to think it won't apply. And so all of the things that would go into addressing whether or not substantial risk of impairment of client representation exist goes into the assessment of reasonable client expectations. And what do you look at? You look at factors such as the nature of the relationship between the firm and the client, the terms of the retainer, the types of the matters involved, and of course the nature of the client. Not said in that paragraph, but undoubtedly true. These slides have come out of order, and I apologize. So if we look at the bright line rule, we realize that it's legal interest, not commercial or strategic. It's direct adversity, it's not indirect. And client expectations, reasonable client expectations, are what matter. We then get through all of that, and if the bright line rule applies, we then look for the test for disqualification. As a practical matter, finding a test is met is uninteresting if one doesn't have a remedy. And the remedy requires you to look at whether or not there's a risk of improper use of confidential information, whether there's a risk of impaired representation more generally, and whether or not disqualification is necessary to maintain the repute of the administration of justice. Sub 1 is McDonald Estate. If you're in the McDonald Estate Martin and Gray case, you fit disqualification test number 1. If you're in the substantial risk principle, if there's a substantial risk of impairment of client representation, you're in number 2. And number 3, I think, but we can't be clear, exists because McKercher fired their client and the court needed a way to be able to whack them if necessary, despite the fact there was no more client representation to deal with. And so my view is that the bright line rule still exists, is still interesting, but at least before the courts, what actually matters in the end is risk to confidential information, risk to client representation, and risk to impairment of the administration of justice. I expect where Brent and I disagree is Brent would say that any time you breach the bright line rule, the repute of the administration of justice is brought into play. He might be wrong, I might be wrong, I have no idea, but we'll have to see how that plays out. So what are the lessons? Candor. Clients are entitled to know the facts relevant to their decision making. Just because a lawyer intellectually clears conflicts doesn't mean that the client isn't entitled to figure it out for themselves, isn't entitled to fire you. And I think just as importantly in clearing conflicts, which I do for a big part of my life, the client may actually know something that you don't and that you should be thinking about, so pragmatically you should ask. Confidentiality, if you can't disclose a retainer against a current client, you can't take it. Commitment, you don't get to fire your clients to clear conflicts, which really astonishes some of my clients. I have a client now, and I won't give you the details, who's really angry that we won't fire another client. And I say, we can't fire the other client, we haven't got cause. And they say, but we're bigger and more important. And I say, I really think you're right, and I really regret that I can't do what you want, but I'm not going to do it. You always have to assess whether or not you've got an interest or a duty which potentially impairs client representation or confidential information. What the Chief Justice said is that the bright line rule applies mainly to criminal and civil litigation when you add up all of the things that she said about the scope. And so I think what you can learn is that if you've got a current client and they're the counterparty in litigation, then almost inevitably, unless it's a really big client, the bright line rule applies. And in some other circumstances, it might. And that's why I think it comes to a pretty narrow rule, all things considered. But I think the bigger conflicts principles really do matter. And so I'm sure I've bored you to death by now. I'd ask that you, when you think these things through, that you go back to first principles, which have worked for generations, which is we don't get to, in our self-interest, mess up or create a risk of messing up the work we're doing for our clients. And that's all. And I did it in time.
There's an academic at the University of Oklahoma who says lawyers advocate, judges decide, and academics criticize. Brent and Malcolm, I think, gave the moderated, thoughtful analysis of the decision, and I'm not just going to get grumpy about it, because that's what I do best. And in a way, what I think I might say about my presentation today, if I was to summarize it in a sentence, it would be to say, I think Brent is right about what the court did, but Malcolm is right about what the court should have done. So I don't know if that's helpful, but maybe I'm going to explain what I mean by 4 little observations about the decision. And the first observation is this: as was noted by Brent and Malcolm, the way the court explained its decision is they said the bright line rule applies, and if it's distinct from the substantial risk test, it's the test on conflicts, and if there's no violation of the bright line rule, then we'll get into the substantial risk principle. And my response to that is that, like Malcolm said, I don't know that it makes sense to think about a conflict of interest without having some sense that there is a risk or a potential impairment of a lawyer's representation of a client. I would ask the court, if the bright line rule is not there to identify a substantial risk, I don't know what it's there for. I mean, there's no point in imposing a prohibition on a lawyer's representation unless there's a reason for that prohibition to arise. And so the bright line rule is useful for thinking about whether a substantial risk has occurred, but I don't see how conceptually you can think about a conflict of interest issue without thinking in some way seriously about what the risk is to the lawyer's representation of a client. I would also note in this respect that when you look at where the bright line rule came from, it really originates in the American law on conflict of interest. And the definition, so in the Neal judgment, Justice Binney uses the bright line rule, but he puts it in the context of the broader definition of a conflict of interest from the American Restatement of the Law Governing Lawyers, which is that there's a substantial risk of an impairment to the lawyer's representation. So my first issue with the McKercher decision is that I think that the court, by putting the emphasis on the technical test and moving away from the emphasis on the substantial risk principle, I think it has made the issue more confusing for lawyers. And I think it's put an emphasis on a technical test as opposed to putting an emphasis on the norms that really ought to govern this, which is, have you as a lawyer put yourself in a position where you might become a crummy advocate? And that's, it's not maybe a very fancy way of putting it, but that would be my first concern with it. My second observation on it, and this is actually a place where I'm very much in agreement with the points that Brent and Richard make, which is that I think I got quite grumpy with the court where they're saying, oh, we're not here to adjudicate this dispute between the law societies. Because as Brent said, the CBA and the Federation weren't standing up there sort of saying, meh, to each other. They were instead articulating very clear positions on how conflicts of interest should be resolved. And frankly, if the court wasn't going to consider those issues, it should be considering them. That was in effect what was on the table, and they had to make a decision about it. But in addition, as well as saying that, which I found sort of objectionable, they also went on to say, in any event, it doesn't matter what we say here to the law societies, because the law societies can always go and put together their own rules. They're not obligated to follow us. And my position on that is that I suppose that's technically true, but it would be a very bad thing were the law societies to have one set of rules about what lawyers had to do in relation to their clients, and the courts were to have another. There's no question that the functions of the law societies and the courts are quite distinct, but a lot of what is necessary here is for lawyers to understand what they have to do. And if the law societies are articulating one set of rules and the courts are articulating another set of rules, what's going to happen is you have a whole bunch of confused lawyers. Perhaps, 150 to 1? Maybe, I don't know whether Malcolm was the only right one or the only wrong one. But in any event, it's really important that there be some common set of standards for lawyers to follow. And I know that the Federation of Law Societies is looking now at this issue of how to rewrite the conflicts rules to reflect McKercher. And I guess I would say, my constructive comment would be that I hope the Federation will try as best as it can to model its rules on what the court said in McKercher. My third comment on the McKercher decision is with respect to a point that Malcolm made about the test for disqualifying a lawyer in that case. And one of the things they said there was, as Malcolm alluded to, that you will disqualify a lawyer if there's a risk of an impairment to the representation or if there's a threat to the administration of justice. But they said, and Malcolm echoed this point, that there's no impairment to the representation where you fired the client. Then we'll only look at the administration of justice. And while I guess that's technically true in a way, it's sort of like saying, well, I can't hurt your leg anymore because I just cut it off. I think it misses sort of the fundamental nature of the problem. I think the problem that needs to be considered in a disqualification application is the impairment in the representation if the lawyer had still been acting on the file. And to call that the administration of justice, I think to some extent softens the importance of the issue, because I think it really does go to impairment of the representation. And in addition, it creates, I think, an unfortunate incentive on lawyers to, despite what Malcolm said, fire their clients and hope that the administration of justice will look okay when it comes out in the wash. And so I would much rather the court had said, impairment of representation is an issue, administration of justice is an issue, but if you fire your client, we will nonetheless consider an impairment to the representation of that client as if you hadn't fired them. So we will presumptively treat you as not having done that. And here's my final point on McKercher. I thought Brent was a little kind to the court here, so I'm not going to be kind. They had to make, the problem with the McKercher case for me is judgments can set out the law all they like, but I do that. I read books doing that, but no one thinks that what I say actually sets any rules, because I don't decide cases. If you want to know what rules mean, you have to see how they play out on the particular facts that were before the court. And all of the facts that were necessary to consider whether to disqualify McKercher were before the court. And there was no reason for them not to make a decision, other than the fact that I very much doubt they would have had a unanimous judgment had they done so. But that very lack of unanimity would have shown us where the fault lines are and would have shown us really what it means to say there's a risk to the administration of justice, or it's not reasonable for a client to object, or any of the other things that they set out. It is an essential part of the role of a court to make those hard decisions and to make the statement about what the law they're articulating in the abstract really means in practice. And I think ultimately we can all stand up here and say what we think McKercher means, but we don't know what it means because they never made a decision. And I think that was, if you want to talk about a dropped ball, I think that was, an own goal, to use a different sports metaphor. It was a very poor choice of the court, and one I think that will be regretted over time. And I think in the end, I guess the last comment I would make, which is not as quite as critical a one and maybe a more positive one, is that I think the point that Malcolm made about commitment and candor, there's a good news story about that, which is, some of us people who don't have exciting animated lives like to spend our time reading conflicts cases, and a lot of conflicts cases. And one of the things that I think you see in those cases, and this maybe reinforces the point around substantial risk and commitment and candor, is that if as a law firm you're basically honest with everyone, you're open about what's going on, you don't try to hide the ball on your clients, even if you are not perfectly in technical compliance with the rules, the court is going to cut you quite a lot of slack. Conversely, of course, if you are not, then there's not much technical compliance which is going to help you out. At the end of the day, it's the Mayor Nenchi's point around politics in full sentences. Client relations in full sentences are also a good idea, and probably at the end of the day are the most important thing for keeping you out of the kind of trouble that McKercher got into. And I'm looking forward to our question period, particularly as, unlike last time Brent and I did this, the representatives of the McKercher firm are not going to be in the audience. So.
So why am I here? Simplistically, it's because Karsten Jensen is trekking in New Zealand, who's the past president of the Law Society, and I'm the past president. But I was the president of the Law Society in 2012 when the Law Society of Alberta adopted a modified version of the Federation's Model Code. Professor Woolley wrote a lovely article regretting the demise of the Alberta Code, and I do share her sentiments. We spent a lot of time on the Alberta Code, and I think it served the profession very well. But in the interests of national standards, we as a law society felt that we had to move towards the Federation's Model Code. And the reason, of course, is that we have national mobility, and it's pretty difficult to argue against national standards when you have national mobility. We, of course, didn't adopt the Model Code in its entirety. We've made a number of amendments to them. We can continue to make submissions to the Federation with respect to potential changes to the Model Code. We continue to believe that a lot of the commentary in the code is important information for lawyers to help them work their way through issues like conflicts of interest on a day-to-day basis. So we'll continue to do that. The other reason I'm probably here is that I happen to be a partner at Norton Rose Fulbright, which is now a global law firm where conflicts are indeed a significant issue, especially since we joined with our American friends last June. The conflict clearing saga is a lengthy and time-consuming process, unless you're in one of the very few circumstances where you get a nil reply from the U.S. I did want to make one point about the disparate positions taken by the CBA and the Federation at the Supreme Court of Canada. I thought it was amusing that the Supreme Court of Canada said that they weren't there to mediate the debate. But I thought that was a good choice of words. A lot of people said it was a dispute. I always said it was a debate. And it was a reasoned and well-articulated debate, and I thought that both organizations did what they were mandated to do. The CBA took a position that supported the interests of the profession, having regard to their professional obligations. The Federation took a position that was consistent with regulating the profession in the public interest. And a lot of what both of those mandates do are the same. Some of them diverge slightly, and hence the debate. One of the things that I find interesting about the McKercher decision is that there is a recognition in the case about large and sophisticated clients. Very few places in the Code of Professional Conduct is there ever a reference to different types of clients. And in fact, I don't think there's many ethical cases that spend a lot of time talking about the difference between an average member of the public and a large institutional client. But in McKercher, indeed in Neil it started, they did talk about institutional clients that were dealing with large national law firms. And there was talk about the potential of using a number of large firms to basically get them conflicted out of acting for other clients. And the court was very, very clear that they didn't condone that at all. And I think that was some good news out of the case. My personal view of the facts of McKercher don't match what the courts decided. Brent went through the 4 matters that the McKercher firm had for CN at the time they decided to take on the class litigation. And the court came to the conclusion that they supported the position of CN that McKercher was a go-to firm in Saskatchewan. Really? A property deal, a personal injury file, a debt collection, and a power of attorney? That's a go-to firm? I think what happened is that McKercher saw that their work that they were getting from CN was dwindling rapidly, and that they were essentially losing them as a client. And when they saw this big class action come along, they made the decision that they were going to take it. So I'm not sure that even though the courts made a clear statement that they weren't going to support the use of the bright line rule and its corollary limitations to support tactical advantages, whether they're well equipped to figure out when those are occurring. It was interesting to me to note that the Supreme Court acknowledged the professional codes of conduct, especially the duty to the duty of loyalty, and made it crystal clear that a lawyer can't withdraw its services from a client without good cause and appropriate notice. I agree with what the panelists have said, and especially Professor Woolley, that it is surprising to me that they did not make a final disposition in this case. They made some clear findings of fact that one would have thought would have supported the conclusion that the McKercher firm should have been disqualified. They chose not to do so. They indicated that there were a number of factors that would be considered if a firm was to be disqualified. They laid them out, then took the easy way out and said, well, we're not really in a position to figure out whether or not those factors apply. We'll have to send that back to the Saskatchewan Court of Queen's bench. I have no idea where that matter stands, but I would be absolutely shocked if the Saskatchewan Court of Queen's bench disqualified the McKercher firm as a result of the comments from the Supreme Court.
They walked away. McKercher walked away.
McKercher walked away. So the matter resolved itself. And I was just going to say that I suspect what the Supreme Court did was they made that determination and probably thought the parties are going to sort this out themselves. And I guess that's what ultimately happened. But I would have been shocked had it gone back to the Saskatchewan Court of Queen's bench and they actually made the decision to disqualify based on the comments. And that leaves the question of, well, if you're not going to disqualify, what are the remedies? You've clearly breached your duties. Is the answer there is no remedy at the courts? That's a matter that's left to the law societies. Or is there some other remedy? Damages? You wouldn't think so. Disgorgement of profits? That hardly seems like an appropriate remedy. So I'm not sure what the Saskatchewan Court of Queen's Bench would have done had they chosen not to disqualify, what remedies would be available. And unless the sanction is significant, what's to stop another firm from doing the same thing in similar circumstances? In my cynical view of the world, McKercher's seeing that they're rapidly losing business from CN, and they choose to take on a very lucrative file from a competing client. So, what does the law society do in the face of the fact that we don't have a final decision from the court regarding sanction? Most law societies contain a provision in their legislation that says that on a discipline matter, the law society must investigate a complaint brought by a member of the public or a client. But most of them also say that when a matter comes to the attention in Alberta, it's when a matter comes to the attention of the executive director, the executive director may, of his own volition, his or her own volition, choose to commence disciplinary proceedings. Well, in this case, the Law Society of Saskatchewan, it would certainly have come to the attention of the executive director that there might be some professional misconduct on the part of the McKercher firm. So what would they do in the face of that alleged professional misconduct? They would go through their normal channels, and if they concluded that the McKercher firm had breached their obligations, what would they do? Well, the first problem is that most law societies in Canada don't govern law firms. We govern individual lawyers. There's some minor exceptions to that. But what the heck would the Law Society of Saskatchewan do in this particular example? Who are they going to prosecute? The head of the file on the Wallace retainer? Would they commence the proceedings against the managing partner of the firm? What do they do? And so I think one of the things that this points out to the profession and the governors of the profession is that there's been a lot of talk about the necessity of law societies changing their rules so that they can govern law firms and not just lawyers. And I think this points out clearly the need to do that. Having disciplinary proceedings against a law firm in a situation like this or an individual lawyer just doesn't make sense. It's the law firm as a whole that made the decision to take on the Wallace matter. And even then, what would the sanction be? Are you going to suspend a law firm? Are you going to disbar a law firm? Probably you can't do that. So what do? Give them a sharp reprimand and tell them not to do it again? Probably you'd do that. And you might fine them a bit, because we can fine. In Alberta, the limit of our fining ability is $10,000. I suspect that that's not going to be much of a deterrence should a similar example proceed in the future. So the other side of what I bring to the table is that I work at a large national firm with international offices. In fact, it's so big that we don't even call it a conflicts committee anymore. It's an amorphous body that has no face or name. It's called compliance. And compliance tells you when you can do something and when you can't. I like to think of the bright line rule, even though it has some limitations on it, as a deemed no trade contract. And while I certainly understand that waivers contained in retainer letters are likely not to be given as much weight since they're done up front as opposed to in the face of a conflict, I think we need to do a better job as a profession of dealing with these issues up front with our clients instead of dealing with them when they get emotional and have time constraints on them. And I think, Brent, in one of your slides, you had suggested that this is something we need to do better. If we want to take on, for example, acting for two bidders on a commercial project that are clearly in conflict because they're competing for the same bid, why don't we say that up front to our clients and say, if you don't like that, we're not going to act for you because we, as a firm, have made the decision that we need to act for separate bidders on large commercial projects. And there's a reluctance, I think, in the profession to do that because people think, oh, well, the client's not going to retain us then. And clients are used to saying things like that because they get away with it. Big banks and big companies say, you're our lawyer and we don't want you ever acting against us regardless of the circumstances unless you come to us and tell us and we give you our consent. And we routinely agree to that because they're big companies and they give us a big amount of fees. But having joined the Norton Rose Fulbright global, can't remember what we like to call it. Swiss Forain, that's right. That's the technical term. I was going to use something a little more self-deprecating, but we are not allowed to do that anymore. There are, I think, 8 global organizations where we are allowed to give that type of latitude to a client, and that's it. And so these are, huge international clients that give the firm worldwide mega billings, and us poor folk in Canada, our best client ever wouldn't even be close to that particular those eight clients. So we can't do that anymore. We're forbidden from doing that. Even if it's the Royal Bank of Canada and they say, you can't ever act against us, we say, sorry, can't do that. We can give you some modification of that, but we can't give you the blanket rule. And the other thing is that I've discovered is that when clients actually get used to the fact that lawyers are going to act on other sides against them, they don't find it that particularly troubling. I do commercial real estate. And in this city, it's a very local practice. If you do commercial real estate, you tend to do it here because that's where the dirt is. You don't go anywhere else. There's very few lawyers in Calgary that do high-profile commercial real estate. There's probably 16 or 20 of us. And we act on the other side of files for clients all the time. And we get conflicts cleared routinely. And the reason is because the commercial real estate business is also a fairly small group in Calgary. And if one of those firms ever took a hard line on a conflicts position, they would be ostracized by their peers. It's just taken as a matter of course that you'll accept conflicts unless there really is truly confidential information that would preclude you from taking the file. My favorite ever conflict story is walking into a room to negotiate a lease. Guy comes in late. He's a co-owner of the landlord. We chat politely about sports and the weather for a while, and he looks at me and he goes, "Refresh my memory. Are you with me or on the other side of this one?" And he truly didn't care. So I think there needs to be a shift in the mindset of lawyers and how they deal with conflicts if we're going to get past a lot of these things. And I think that there needs to be a shift in the mindset of certain clients. And I think it's possible, but we need to think about that stuff. We need to think about it early on in the process and not deal with them at the last minute when there's time constraints and emotions involved.
So we do have a few minutes for questions if people have any for the panel.
I have a question, but I cannot position myself as a client or whoever, but I maybe know about the international laws and laws more than many people in the room. So, from perception from the client, it strikes me that none of you actually talked about the big client perception. Because if I run my own companies, I wouldn't go to these companies again because I know these big firms can disclose confidential information. So none of you describe it from the client approach to the legal system or to the sophisticated client from marketing. But the question is simple. When we go to this medium-sized companies, they say, legal firms, they say, we do conflict of interest check on your business and your directors and whoever's there. What does it take it to put the Canadian system into this position in this case? This case, when we look at it from international perspective, it's a big black spot in the Canadian legal system. That's a law firm with this particular size will go up to the Supreme Court to get a message. You go back and follow your own rules. So, can just somebody tell us quickly the dynamics? What does it take this to go to the Supreme Court, and why did it not work early on? Especially if you say the same Krishna company walked away right now.
I think the practical answer is that there was, after the 2002 decision in Neal, there was very substantial debate in the courts and in the profession as to what Neal and Strother meant. And Brent and I disagreed completely on that, and we both thought about it pretty carefully. And the fact that it was unclear can be demonstrated by the fact that the first two courts analyzed it quite differently than the Supreme Court of Canada. And so it's not a case where it would be fair to the McKercher firm to say, you got it wrong, how on earth could you go all the way up to the Supreme Court of Canada to be told just to follow the rules? Supreme Court of Canada changed, in an important way, what had been decided in Neal and solved a controversy about what Neal meant, and it required the Supreme Court of Canada to do that.
I have a question. It's a bit of a practical question, perhaps you'll forgive. But Steve raised the point that what penalty would you give to someone who is found, not someone, to a firm, found guilty of conflict of interest in this case? So I'd like to ask the three of you guys, what do you do if you were in charge?
I have disqualified them. I think it's the only meaningful, here I think ultimately the only, given Law Society's limited jurisdiction, the only meaningful consequence was disqualification. And the fact that they didn't disqualify them, that's why it's such a confusing case, because on the one hand, they set it up so the answer is going to be disqualification. It's like you did this wrong, you did this wrong, you did this wrong, you did this wrong, and you're waiting for the punchline, and it never happens. And so the question, I think Steve's absolutely right. The question is the message of this case, McKercher, the firms who do what McKercher did wrong things, or is the message of this case, firms that did what McKercher did, good news, you might get, some bad things said about you, but at the end of the day, nothing might happen to you. Because I think if it had gone back to the Queen's Bench, there's a good chance they would not have been disqualified.
I think it's intolerable that you fire your client and that's the only way that you avoid disqualification. I think that can't work. I think they should have been disqualified. I think it's simple.
In some aspects of those four continuing retainers, the firm sought to stay on the file and the client fired them. But I don't think it makes any difference in this respect. As far as I can tell from reading the Supreme Court decision, the only ray of hope that the McKercher firm had of staying on the file when the trial court judge would have reconsidered this was a statement by the Chief Justice that the McKercher firm no longer represents both clients. CN is gone. And whether the firm fired CN or not, or took some steps that drove CN away, it kind of operates like this. It would be, and I told the senior counsel, all these lawyers are friends of mine, and it's kind of awkward. I told the senior litigation lawyer that when you take that argument to the Court of Queen's Bench in Saskatchewan, it's like saying you want sympathy as an orphan because you've murdered your parents. They drove the client away, so the idea that now they only have one client, that dog doesn't hunt. So it's unquestionable, in my view, that they were going to get disqualified at the trial court. I don't think and there are a variety of kind of, let me call them, contextual factors that I think lead in that direction. But a larger question would be, in circumstances where if you were engaged in firm regulation, how would you impose some kind of a sanction? Steve asked a very compelling question there. And it seems to me what's likely to be the case is that you end up as a firm put on ethical probation. And Alice is brought in to oversee, or Malcolm. I'll tell you, when we say Alice, they'll start behaving in society. To oversee the ethical infrastructure of the firm. And my sense is that that would be a scary thing for a law firm to have to submit to outside oversight of whether it's behaving in an ethical manner. That kind of cracks the whip. And I like that idea as a way of causing firms that are struggling on these fronts to do better. Could I just add one other observation about the McKercher law firm? In some ways, Steve indicated the trend at the firm. It was doing less and less work for CN. It was doing more and more work for farmers, and on a variety of fronts. And it was actually probably the firm that best and most effectively represented farmers on big matters. So it's not unreasonable that they might have thought that they were an appropriate firm to take this work. On the conflict topic, I think they made a conscientious effort, but made a bad call. And I told them all the way through they were making a bad call, and I was repeatedly wrong. It was looking like Malcolm was going to be right on that point. But it was done in a principled way. they felt that the CBA interpretation of Neal was a legitimate guiding approach, and they tried to follow it. Fair enough. And I don't think they deserve to be disciplined on the conflict of interest question. The right punishment is disqualification. On the other questions of candor and commitment, they do deserve to have their knuckles rapped, because they basically were trying to get rid of, strangely enough, a giant company so they could take on a more lucrative client. And that wasn't honorable.
So all of these cases are in fact specific, of course. And McKercher, they traded the new client for the old client. But what about the situation that happens all too often in real life? You got two long-term clients and the new file pops up. How is that different from Scripture? I mean, what if Wallace had been a client for 30 years?
A lot tougher to fire him. It's a lot tougher
Who do you
not to
fire?
The answer is you don't get to. I think the bottom line answer is just because you know, it's much easier in your self-interest if you've only got one relationship you want to protect. But as a fiduciary, your problem is you got to protect both, and so you got to go somewhere else, or they have to go somewhere else. It doesn't solve it because you've got two great relationships, neither of which you want to break.
I think as well, if you're representing those two clients, you've been representing them in uncontroversial, non-direct adversity matters as between the two. So the client, one of those long-term clients, comes up with a new and legitimate claim, but it's a brand new file against that existing client. And absent consent, if it meets those requirements, you have to say, no, we like you as a client, this piece of your work we can't do.
We have to say no both.
In terms of, and then of defending them, that might also be the case. Yeah.
Can I just ask one more clarification? So when you look at the firm merging, and there is a big nice example of merging law firms, how much of this rules will play exactly? Because it will make a better sense when you merge two big law firm, and if both of them will do litigation, and they have different conflicting clients, you have the rights now to fire or decide. Can you just give a comment on that?
I could go to Malcolm and get all my conflict issues solved if it wasn't for a conflict of interest issue in 1985 that resulted in the fact my firm didn't merge with McCarthy Tetrault in 1985. Seriously, it was a conflict issue with a major client that resulted in a merger not occurring.
It's actually interesting, when you have mergers, is the conflicts rules do apply, and it's about the only time that you'll get lawyers actually on opposite sides of a dispute, which is a rule that everyone knows you can't do that, and then law firms merge and suddenly the firm is doing that, so it is significant. I get the happy task now of thanking you for coming, thanking both Miller Thomson and the panelists. I have to say, personally, Ian already spoke to appreciation for Miller Thomson's sponsorship, but as the person who does ethics at the university, to have Miller Thomson supporting our students directly every year to support this series and to have helped make the ILEC conference, International Legal Ethics Conference, possible is truly fantastic. And we're really grateful to them. And for me to have had Brent and Malcolm and Steve here today, it's just really great. So I'd like to, on behalf of the Faculty of Law, because Ian had to leave, thank all of you for coming, and thank our panelists, and thank Kent and Miller Thomson. So thank you.